Imagine this. You're walking down the street minding your own business, and suddenly a police officer steps in front of you. Hey, can I talk to you for a minute? Your heart rate jumps a little. You haven't done anything wrong, but that doesn't matter, because in that moment, what you say next can shape everything that follows. There are four things, and only four things, that you should say when you're stopped and questioned by police. Four simple statements that can save you from months, maybe years, of legal trouble. Let's get straight into it. If an officer approaches you and starts asking questions, the very first words out of your mouth should be calm, clear, and controlled. Am I free to leave? That single question is powerful. Not aggressive, not disrespectful, just direct. Why is it so important? Because it forces clarity. The officer now has to respond in one of three ways: yes, no, or some variation designed to pressure you. Something like, "Why are you being like that?" Or, "What, do you have something to hide?" No matter what tone they use, those are essentially the only directions this can go. If the officer says yes, then that tells you everything you need to know. The interaction is voluntary. In legal terms, it's called a consensual encounter. That means you are not detained. You are not under arrest. You are not obligated to stay. And if you're free to leave, leave. Don't debate. Don't explain. Don't try to be clever. Just walk away calmly. In a voluntary encounter, police officers are allowed to approach anyone and ask questions. They can ask what you're doing, where you're going, whether you've committed a crime, what's in your pockets, what's in your bag, whether they can search your car. They can ask almost anything. But here's the key: you don't have to answer. The Supreme Court has made it clear that during a consensual encounter, you are free to ignore the officer and go about your business. It's not an arrest. It's not even a formal stop. It's just conversation. Because of that, they cannot use force. They cannot command you to sit down. They cannot order you to put your hands up. They can't surround you with multiple officers in an intimidating show of force. If it's truly voluntary, it has to feel voluntary. So if they say yes, you are free to leave, that's your green light. Walk away. Now here's where it gets interesting. Sometimes officers don't like that question. They may respond with attitude. "Why are you acting like this?" Only guilty people say that. "If you've got nothing to hide, just talk to me." This is psychological pressure. It's designed to make you uncomfortable, to make you comply. Stay calm. Repeat the question. Am I free to leave? You don't raise your voice. You don't argue. You don't justify yourself. You just calmly ask again, because until they say no, you are still in a voluntary situation. But if the officer says no, you're not free to leave, everything changes instantly. At that moment, the encounter is no longer voluntary. You are either being detained under what's called a Terry stop, or you are under arrest. Now here's the part most people don't realize. Even judges and experienced lawyers argue in court about whether a situation was truly voluntary, a detention, or an arrest. These distinctions are not always obvious, but you can make it simple for yourself. If they say you are not free to leave, you now know you are being detained in some capacity. A Terry stop, named after a Supreme Court case from 1968, allows officers to briefly detain someone if they have reasonable suspicion that a crime has occurred, is occurring, or is about to occur. Not proof, not probable cause, just reasonable suspicion supported by specific facts. During a Terry stop, officers can temporarily hold you and, if they believe you might be armed, perform a limited pat-down for weapons. Notice the word weapons. They are not supposed to search for drugs. They are not supposed to search for soft objects. The pat-down is strictly for officer safety, for things that could harm them. But here's another critical detail. During a Terry stop, Miranda warnings are not required. That means they can ask questions, and anything you say can still be used against you, even though you haven't been read your rights. That's where most people make the biggest mistake. They start talking. They try to explain. They try to appear cooperative. They think that if they just clear things up, everything will go away. But the street is not the place to defend yourself. So if you are told you are not free to leave, the next three things you say matter just as much as the first question. You say, "I plead the fifth. I want a lawyer. I do not consent to a search." In that order. Calmly, clearly. When you say "I plead the fifth," you are invoking your constitutional right to remain silent. You are telling the officer you will not answer questions that could incriminate you. When you say "I want a lawyer," questioning is supposed to stop. Once you request an attorney, interrogation must cease until one is present. And when you say, I do not consent to a search, you are preserving your rights. Even if they search anyway under some claimed legal authority, you have made it clear that you did not voluntarily agree. Those three statements shut down most fishing expeditions immediately. Now let's address the common reaction. But I don't have anything to hide. Why would I need to say all that? Because you don't know what the officer is investigating. Maybe a crime happened nearby. Maybe the suspect was described as wearing a white shirt and a blue jacket, and that's exactly what you're wearing. Wrong place, wrong time. You start answering questions. Your timeline isn't perfect. You hesitate. You misremember something. Suddenly, small inconsistencies appear. In court, a prosecutor can say, were you lying then, or are you lying now? That's powerful. Even innocent people get nervous. Even innocent people make mistakes when speaking under pressure. And here's a reality many people don't like to hear. Officers are human. They want to solve cases. They want results. If you appear to fit the story even partially, it becomes easier to focus on you rather than continue searching for someone else. If you talk yourself into a corner, you can unintentionally make their job easier. And being cooperative does not guarantee leniency. An officer might write in a report that you were polite, but that won't outweigh damaging statements you volunteered. It won't erase inconsistencies. It won't undo admissions. The roadside is not a negotiation table. It's not a courtroom. It's not a place where your explanations are carefully weighed in your favor. It's a place where every word can be documented and later used strategically. Now, if you truly are under arrest, that becomes more obvious. You may be handcuffed. You may be transported to a station. At that point, Miranda warnings are required before custodial interrogation. But the line between a detention and an arrest isn't always crystal clear at the beginning. That's why your first question, am I free to leave, is so critical. It draws a bright line. And once that line is drawn, your job is simple. Protect your rights. Let's recap the 4 statements that can save you enormous trouble. Am I free to leave? I plead the 5th. I want a lawyer. I do not consent to a search. Nothing more, nothing less. No stories, no explanations. No attempts to outsmart the situation, just calm, controlled assertion of your rights. This doesn't make you guilty. It makes you smart. It doesn't make you uncooperative. It makes you legally protected. Even if you are guilty of something minor, speaking without counsel rarely improves your position. A lawyer can negotiate. A lawyer can assess evidence. A lawyer understands strategy. You, standing on the sidewalk under pressure, do not have that advantage. And if you are innocent, then protecting yourself is even more important. Innocent people have been charged and convicted based on misstatements, misidentifications, and misunderstandings. The legal system is complex. Your rights exist for a reason. So the next time you see flashing lights in your rearview mirror or an officer approaching you in a parking lot, remember this moment. Slow your breathing, control your tone, and remember the 4 statements. Because what you say in the first 60 seconds of a police encounter can echo for years. Know your rights, use them calmly, and never let pressure trick you into surrendering protections that the Constitution guarantees you. If you found this valuable, share it with someone you care about, because information is power. And in moments like these, power begins with just 4 simple sentences.